Hey, folks, welcome to another show of Ask a Lawyer Live. I'm Dave Brannen, lawyer here at Resolute Employment and Disability Lawyers. Today's our live show edition. So let's get in here. So with our live call-in show. So this is the day when I take phone calls, or try to anyway. We'll see if it works. We got it to work last week. Hopefully it'll work again this week. So if you're someone attending and you want to call in, we can talk back and forth about your case, and then I can give you a little better advice. Remember, this is public, so that is one of the things. It's not a private legal consultation, but if you have questions, it's easier to talk back and forth than just to type in questions. That being said, if you're a little shy, you don't want to call in and be live on this show on YouTube, you can just post your questions in the comments, and I'll also answer those questions here today. All right, let me get a little drink of water here. Been a bit of a busy day, been a busy week trying to launch a new website. It's been anyone who's ever launched a large website knows how difficult it is. So we're still about a month away from it actually being launched, but I've met with my people who are building the website, and hopefully we're getting close to a launch date here, or getting close to everything that I have to do on my end. But I'll be glad when it's ready to go. Let's put it that way. Trying to redesign the website to be a little more user-friendly and look a little better in certain ways. So it's been a long time since I've updated the website, and we're looking forward to it. Okay, so we're waiting for some calls. I did figure we could be waiting a little while for people to call in. So what I'll do is, while we're waiting for calls, I'm going to talk about some different things here. So first thing I'm going to talk about is this issue of if you're not satisfied with how things are going with your CPP disability claim, is there a way to file a complaint that will actually get something done with Service Canada? And the answer to that is yes, there actually is a way to file a complaint. You do it through something called the Office of Client Satisfaction. And if you give me a second here, I'm going to share my screen here. Right here, share screen, right here. Boom. Okay, just bear with me here so I can see what I'm doing. Okay, so there it is. Office of Client Satisfaction. This is an interesting thing. Actually, I had, it wasn't a client, but it was a client. I can't remember if it was a client or not, honestly. We wrote an article about it. I think it was a client of ours who went through this process and actually it did work. The Office for Client Satisfaction is important because sometimes when you submit in your CPP application, it just seems like it goes off into wherever it goes, and you just never hear back. Normally, they have service standards that they're supposed to process, and I forget actually we'll look here and see if we can find the service standards, but they have service standards that are like 4 to 6 months or something like that, but often it can take much longer. So actually, I think the service standards are 4 months for a decision. But let's say you're waiting 7 months, 8 months, 9 months, a year. Like, at some point, you have to do something. You just can't wait forever. And one of the things you can do if you find yourself in that situation is go through the Office of Client Satisfaction. It did work the time that, there's not a lot of information there. They're kind of like an overview. They're like an ombudsman, if you know what that term means, for Service Canada, and they will go investigate. And that will often get things done because often it's a breakdown somewhere at a lower level, and the higher level people, they want to meet. Like, they're being judged on whether they're all meeting the service standards. So if this is one that's sort of slipping under the radar, going in for the Office for Client Satisfaction can absolutely result in things happening faster. Let's take a look at the article we wrote about this. Here we go. I'm going to show you the article. Let's see here. Right here. Okay. So this is the article right here. How to file a complaint against Service Canada. This is an article on our website. I can probably, I'll post this in the comments if I can. Actually, I don't know if I can do that. Let's have a look. Can I post that? I think I can right here. There you go. Yeah. So there's the link there. Oh, I see people are starting to put comments in too. So that's the link for this article. If you want to read it over, this I'll just do this and then I'll answer the questions that people are posting in there. So it talks about the Office of Client Satisfaction, and if you Robert was the guy. I don't know if that's his real name. We might have changed it up, but he talked about um, his process of going through this. So, and since this time, we've sent other clients and other people who've contacted our office to go through the Office of Client Satisfaction. It does work. It will speed things up. Now, when to file a complaint, try everything possible to get things resolved directly with your person you're dealing with. But sometimes that honestly, in the beginning, you're often just calling into a call center and they say, someone will get back to you in 14 days. Like it's like kind of maddening when you do that a couple of times. But just follow the process to go through that Office of Client Satisfaction, put in a complaint. It needs to be a complaint. The complaints that work are ones where it's a service level. You can't really complain that they denied the case or they didn't accept this evidence or something. Those kind of things they don't deal with. They deal with things like, I submitted my application and it's been 7 months and I've not gotten a response. That's the kind of thing that you can work with them on. All right, let's look at some questions here. So we've got too much red tape. Yeah, there is a lot of red tape. Need DTC and household income is way too low. Yeah. The DTC, there is a lot of red tape with that. But it is a single form. So compared to some of the other applications, it is simpler in some ways because there's just the one form you fill out that you and your doctor fill it out. Maybe let me know some of the issues you're having, Sherry, and I can maybe I can shed some light, or maybe not even. But there can be a lot of red tape. Even dealing with lawyers is a level of red tape. Like, don't worry, I completely appreciate that it's not everybody's dream to deal with lawyers, especially with these types of claims that really should be approved. Jay's home opener, time to stop. Oh, it is the home opener. I didn't realize that. Uh-oh, you're right. Shut this thing down. I used to be a super Jays fan, and then I kind of fell off in the last few years, but maybe it's time to get back in. Well, you enjoy that Jays game, Josh. I might catch the highlights later. I'm sure my father-in-law is watching. All right. I'm going to put the call-in number back up in case anyone wants to call in. Let's see. Oh, yeah, we got questions coming in left and right here. So here's one. I'm off on WCB Alberta. My claim to get approved. However, when I requested all shared with me, I noticed that work had said I'd received disciplinary actions, which isn't true. Huh, interesting. Yeah, you could definitely put your side of the story in there. And you want to know, should I address it? Because clearly I misrepresented myself in this situation. They do not know. I have all their go-between communication. Yeah, you could do it in a professional way. You could notify Alberta that you dispute the fact that there's disciplinary actions. I don't know that will really matter for the purposes of your workers' comp claim. Sometimes employers get very defensive about workers' comp claims, especially when they're contesting that there was an actual injury, and they'll bring up all this other dirt. In fact, I was once at a workers' comp hearing, and I told my client before we went in, I said, look, sometimes the employers go way overboard. The best thing you can do is just sit there and just listen to it and let the judge be the one to get angry at them and tell them this is completely irrelevant. So we did that, and the client, thankfully, just sat there quietly while the employer was throwing all this dirt and irrelevant things, and it did infuriate the judge. So this could be one of those things where they're just trying to sling a little mud because and I don't know your situation, but that could be what's going on here. Some employers will try to focus on that, but they'd have to have proof of any of such actions. Like, they need to show you receive written warnings and have copies of them that you signed and all that kind of stuff. So it sounds like they may not have all that. It sounds like they definitely may not have all that. All right, there's our call-in number if anybody wants it. Okay, I'll keep an eye out for comments as I move along here. Another thing I was going to talk a bit about was the change of definition of long-term disability. Someone asked, I think yesterday or the day before, they asked if I could cover what happens after the change of definition. So I thought today we would just, if we have time here, I was just going to talk a bit about the change of definition. This mostly will just apply to people who are dealing with right here. People who are dealing with long-term disability claims often come up with this issue of change of definition. So this article, again, on our website, goes through the change of definition, gives different examples. The big thing to keep in mind, if you're unfamiliar with this concept, is long-term disability insurance has a kind of two-step disability criteria, I guess the best way to say it. CPP disability doesn't have this. Workers' comp really doesn't have this. Whereas with group insurance or private insurance, long-term disability insurance, they will insure you for a period of time, usually 2 years, if you can't do your own occupation. So they kind of give you time to try to get better, try to get back to work in that period of time, where they will pay you to be off and give you a chance to try to get back to your regular occupation. Now, once the 2 years is up, the definition changes so that they move on from, okay, we're not going to pay you anymore if you can't do your own occupation, but we will only pay you if you can prove your disability is such that you can't do any occupation. And that is kind of where people get caught up with this issue. Many claims get denied. In fact, the most common time, if you're on an approved claim, the most common time for your claim to be denied is at the change of definition. And the second most common time is like a month before the change of definition. And the third most common time is like a month after. So it's all a lot of denials happen right around this change of definition for people who are on an approved claim. It's the most common time. I got those statistics from the insurance company who did their own claims analysis that comes straight from them. So we know that if you're on an approved claim, now claims obviously get denied right off the bat, but if you're on an approved claim, the most common time to be denied is at the change of definition. And it makes sense. A lot of insurers will concede that you can't do your own job, but they will say that you have still a level of abilities that you could go and do some other type of work. This article just takes you through it. It shows you examples of the wording. So, this is an example of a letter that would be sent to you saying that you're being denied. So, if you look at this letter, it just says, as advised, our letter, yada, yada, benefits are currently paid on the basis that you are totally disabled from performing the essential duties of your own occupation. And then they talk about the change in definition date. Yeah. And they talk about this change of definition date. So that is an example of what these letters look like when they talk about the change of definition. This letter is like warning that the change of definition is upcoming. They're going to be doing a review. So it's quite common when you are approaching the change of definition that the insurance company will do a lot of work to determine whether they will approve you beyond the 2 years or not. In fact, usually at least a year out, they will start ramping up getting information because they want to have everything there to justify if they're going to justify cutting off your benefits. They want to do it before the 2 year happens. Kind of a worst case scenario for them is if they haven't done a well enough job to get everything in time, they can leak you into, in their kind of view of it, you will leak over into any occupation, and they will approve it kind of on they call it like they will kind of tentatively approve you past the 2 years, but while they continue to investigate. And that's when you will have people complaining that even though they're past the 2 years, they're still having to check in every month, give information. That's because the insurer is still actively investigating. They didn't get it done in time for the 2 years. Sometimes it's not done in time because of just their own fault. They were too slow to do things. But it can also be maybe you delayed getting things to them sometimes, or your doctors, and that can kind of stretch things out. That's why you'll see a lot of these insurers start ramping up, doing these investigations into whether you're going to be able to go work in other occupations. They'll start that up like a year out at least. There's another YouTube video on me talking about it. Here's a sample of a definition of what they look like. This is what a disability definition looks like for see if I can make that bigger. Yeah, it doesn't really make it much bigger. That's what it looks like for people on long-term disability. It has this two-step. So it says his own occupation for the first 2 years, any occupation after 2 years. You'll see this one specifies now. This is a good point. It's not literally any occupation. Keep that in mind. Insurance policies will go to different extents on how they'll define what any occupation means. But you'll see here, they've defined it as any occupation where your earnings are 75% or more of your pre-disability earnings. So just keep that in mind. Like, it does not literally mean any occupation where you could be paid anything. It would mean any occupation where you could be at least 75% or more of your pre-disability earnings. Now, a thing that's come up recently is I noticed there was a recent insurance policy that's 75% of pre-disability earnings, and they did clarify that it would be adjusted for inflation. So that is something you can argue, like, because your earnings might be from 3 or 4 years ago, and it's not really fair to judge a current salary based on a salary that has not been affected by the inflation in the last few years. So that is something that they may want to inflate it to show. They may want to use inflation to raise your previous salary to make it easier to find you one today. However, if your policy doesn't have that in there, then it probably works to your favor because the salaries have inflated possibly, and your old salary would remain lower. And so it kind of works both ways. And many times we will want your pre-disability salary to be adjusted for inflation because it would raise the amount that you have to make currently in order to meet this criteria. I know I'm kind of talking in circles here, but hopefully that makes sense. Just keep in mind that it's often it's related to your pre-disability income, whether you are totally disabled from any occupation. It's going to be a percentage of your pre-disability income, and that can be adjusted for inflation either through a policy, or you could argue through the common law that it should be done to make it fair. So I make the same point here about any occupation. It's not literally any occupation. Here's what I've kind of already touched on this, but in the months leading up to this change of definition, they could get you to do medical appointments with their doctors. Often they'll have you whether they do it with you directly or reviewing your information, they will hire a vocational expert who will try to figure out if you have transferable skills that would make you employable in these other jobs in the economy. There are vocational resources out there and a job data bank in Canada that kind of sets out jobs with the physical and mental requirements and also the salaries. So there is a way for vocational experts to take your information about your work history, your education level, and your skills, your abilities, your restrictions, plug it into a computer and spit out theoretical jobs that you would be able to do that match the earnings level that you'd have to get to be like 75% of your pre-disability earnings. So you will often see those reports. The insurance company get those types of reports. And if they get one that spits out jobs that you technically could do, they will review. Usually they will review and see if those jobs exist in your area. And if they do, then they will say, look, you should be applying for those jobs. There's work out there you could do, and we're cutting you off. These kind of reports can be kind of a little problem. They're often factors they're not considering. So they are easy sometimes to take down if you know what to do against these. They're called transferable skills reports. And if you know about how these reports are done and what the weaknesses are, you can kind of take them down. For example, they need to be comprehensive and take into account all your medical information. Sometimes they will miss key things like they will use jobs where you don't actually have the standing or sitting capacity or mental processing ability. They'll miss out a key component like that, and it will rule out the jobs that they're recommending. Mm, yeah, this is just talking. I'm just talking here about medical IMEs and things that can get done that will take you through that in the lead up. All right, let's see what else I got here. I've been keeping my eye out for any new updates on the Canada Disability Benefit, but there's been nothing so far. Let me just double check here again today. Yeah, I don't see anything new. Right now, we're waiting to find out when the applications are going to go live. I'll share my screen here if I find anything. Yeah, it's bringing me to Canada Pension Plan Disability. We want Canada Disability Benefit, and I don't see anything yet. Certainly, if you are thinking you would like to get the Canada Disability Benefit, you would need to be a lower income person, someone with a lower house family income between you and your spouse. You'd have to be between 18 and 64. You'd have to be on the disability tax credit, and you'd have to have filed your taxes last year. So the income levels are like 23,500 and I think 32 something for a couple. So the thing to do would be to start the process of getting your disability tax credit application in, and to also get your income taxes filed. Those two things have to be done in order to qualify. The application should be out. The application should be out here soon in May or so, I'm thinking. So in a couple months. And the benefits are going into effect later this summer in July. Will be the first month that people can get them. All right. This is where you can go and get information on this. Right here. This is the page. So there's not a lot of there's nothing new here, honestly. But it does go over the basics. And if you click down here, it does take you to a page where there's more background information and things like that. But I've subscribed to this. I don't even know if I've got an email. They're supposed to give updates and things. I might have subscribed twice. I'm pretty sure I've subscribed a while ago, and I just resubscribed again today. Yeah, there's nothing new here. Summary of benefit yeah, the regulations came out. I've gone over these before, but I'll just take a peek and see if there's anything new here. I don't think there is. These are all the eligibility requirements. So if you know anyone that could get this benefit, it would be up to $200 a month, which is not bad, which is not great, but it's also $200 is $200. So, and it is not supposed to deduct from any other benefits you're getting, which would be great. And you can have some earnings. So as we'll see down below here, yeah, there's the amount. So you have to have a single person with a $23,000 income, or a married person or common law person who has a combined income of 32,500 or less. If you're over this, you would still get some amount of the benefit, but it's reduced 10 cents for every dollar over that amount. So I worked this out. I think it's like $12,000 is how it works out. It's 20 cents. It's reduced 20 cents on the dollar. Oh, if one person. So it's 20 cents if one person is getting the benefit. If both spouses get the benefit, it's reduced 10 cents. Yeah. So there's a period after 2,300 if you're single where you keep getting the benefit. It won't be $200. It'll reduce by 20 cents for every dollar you have over 2,300. And it says working income. So if you have employment or self-employment income, they will exempt you up to 10,000, so that won't count towards the 2,300, which is great. So you're allowed to make a little bit of income. So you really have to be making 33,000 once you take in this. You take into account of this, that would put you under the limit. Yeah, see, here it goes. Benefits payable to person the month after. So the first month anyone can apply for this is in June. With your first pot, like the earliest benefit you could possibly get out of this is going to be payable in July. So people who get an application in for to be approved as of June, their benefits would go from July 2025 to June 2026. You can apply retroactively, so you don't have to apply like immediately. You don't have to have an application in for June. Like you could apply after June, and your application can be backdated so that they will assess you going back to June. So don't worry about that if there's a bit of a delay. I think it's quite a. They said somewhere how far the retroactive period can go back, and it was quite a bit. So it allowed. Maybe it's listed here somewhere. Yeah, 24 months of retroactive pay, which is great. CPP only goes back 11 months. So you can go back 24 months, which is fantastic. So in theory, you could apply, you could be 2 years past June and apply and still have your benefits retroactively approved to June. Okay, so that is good. That's a good sign, or a good feature of this plan. Yep. All right. Enough of that. All right. I got one other thing I can go over, and then maybe I'll go watch the Blue Jays game if I got some time here tonight. I don't know if anyone else is up for that. There's Blue Jays fans in here. The other thing we could look at is, this is a common one that people ask about. Let me share again. There we go. Just bear with me while I get my screens. I have to buy another computer screen to make this easier to do. Here it is. Boom. So aggravated and punitive damages in long-term disability lawsuits. You can't get these in CPP or workers' comp, just so you know. But in the world of long-term disability insurance claims, yes, it is possible in some cases to get aggravated and punitive damages. These are damages that are not included in the policy itself. They're called extra contractual damages. Damage is just a word that says compensation that a court can award for some wrong that's been done to you, some harm. And you can get these types of damages. They are two different things. The aggravated damages are also referred to in the context of long-term disability as mental distress damages. Words are kind of used interchangeably. They're technically not the same thing, but they're often interchangeably used. Mental distress damages, aggravated damages. These are payable when the insurance company's actions in denying your claim have caused you to suffer mental distress to beyond like what anyone might, beyond a minimal level. So it has to be something beyond a minimal level, but it doesn't have to be super high. As long as you can prove that it did cause distress, you can get compensation for it. Now, insurance companies they're not jumping to pay this. And often you have to the only way you would actually get this in reality is through lawsuits. And, even if you settle a lawsuit, they will not agree that any amount of it is for aggravated damages. But if an insurer believes that they have a real risk of paying these, it will inform how much they settle a long-term disability lawsuit for. Even though they're not admitting that they're paying these, it can inform the amount. Like you might be able to settle for a higher amount, even though they're not acknowledging it. The way it gets acknowledged is if you go to trial and a judge awards these. Awarding it means the judge here's the case, gives a decision, and part of the decision gives out the compensation they're going to pay that the insurance company has to pay, and they can include aggravated mental distress and punitive damages. Punitive damages are slightly different. These aren't, so this is meant, aggravated and mental distress damages are meant to compensate you for emotional harm that you've gone through. So you've actually suffered harm. Punitive damages are different. They're not meant to compensate you for anything. They're meant to punish. They're literally meant as a punishment, a fine, so to speak, for the insurance company to punish bad behavior so that other insurance companies are less likely to do it. It's punitive. It's meant to punish them. You don't even have to have suffered a loss. These types of damages are very hard to get in Canada. They're much more common and easier to get in the United States. And a lot of people hear about court decisions and big things. They hear about it from the US, but it is much harder to get it in Canada. The behavior has to be so bad that it is they use words like shock the conscience, which is kind of a weird thing to say, but it has to be so far out of the bounds of decency that a court says, yes, we definitely have to punish them. Again, courts are all over the place on this. So obviously there's some subjective element here on whether something done by the insurance is bad enough for them to be punished with punitive damages. But it's worth looking into. You have to be able to prove it through paperwork. And but again, I tell people, like, don't fixate on it too much unless you plan on taking your case to a trial, which is very rare to happen in Canada because most cases either get approved before a trial or there's settlements out of court settlements. Unless you go to a trial, it is very impractical to get punitive damages. It's very risky to go to trial to go for those. There are some recent examples where clients were given significant punitive damages at trial in cases. These are some historical cases we've listed here. This Fiddler one is like a famous case. This is the case in Canada. It happened right after this is the Court of Appeal decision. I graduated law school in 2004, I believe. Yeah, 2004. So the earlier Fiddler cases were going on when I was in law school. And then when I got out, this Court of Appeal decision came out in 2006, I believe. But in that case, the court awarded $20,000 for mental distress and $100,000 for punitive damages. This case later went on to the Supreme Court of Canada, and I think we mentioned here the Supreme Court of Canada. Yeah, they set aside. So this is a classic thing that can happen. So this poor person went to court, got awarded $20,000 for mental distress and $100,000 for punitive damages. But when the case got appealed to the Supreme Court of Canada, and they set aside this $100,000, so she didn't get that in the end, which is kind of terrible when you think of it. She would have had a lot of legal fees with all these appeals, and it's likely the legal fees outstripped what she got with all these awards and things because of all the legal fighting. That's why it can be unpractical sometimes to go after these unless you are going to try to prove a point. Because originally it seemed pretty good, like $100,000 for punitive damages, but then that got reduced to $0 by the Supreme Court of Canada. There's other decisions here people can read over. Often not a good reason to pursue a case if you only are trying to go after punitive damages. You'll find it hard to get lawyers to go after those kind of cases because of how difficult it is to prove, and you also need, especially in Canada, like a lawyer will do a case like that if the evidence is there that you can prove it. It's often that is the hard part, trying to get the evidence. All right. Well, I think I will go and join. Who was it that was going to the Jays game? Josh. I'm going to go join Josh, maybe checking out the Blue Jays if it is the home opener starting here. I mean, it's snowing outside here, so if they're doing a home opener, I hope they have the roof closed in Toronto, if that's what's going on there. I'm probably going to take tomorrow off. It's been a busy week, so I'm going to take tomorrow off of the live stream on Friday, but I'll be back on Monday, and we'll post. You'll get an email Monday morning letting you know what if you're on our email list, you'll get an email Monday morning just giving you the topics that are coming out next week. I do know that someone requested on Tuesday I do a topic on what happens after the 2-year change the definition of long-term disability. So I'll be talking about that on Tuesday. Sorry, Monday we've got a CPP disability topic, and we'll have a topic on employment law on Wednesday. Then we'll be back next Thursday with this live call-in show. I wish you guys all well, and I hope you have a good weekend, and I'll see you back here next week. Take care. Oh, wait a minute. Someone got a question right under the wire. Let's see. CPP. So let's see what we got here. CPP submitted June 24th backlog, and they have sent a request for more info to my doctor. She won't make the deadline. I called to get more time. Will it be okay? Okay, yeah. So this is a situation where someone's got a CPP disability claim, and you have to do an appeal within 90 days. So I think what this person is saying, like, she's trying to get info from her doctor, but won't be able to get it in time for the 90 days. So that is fine. But what you need to do, we do this all the time when representing clients. What you have to do is, in writing, you still need to send in to the CPP a request for appeal. Reconsideration is where you're probably at here. So you send in a request for reconsideration and just say on it that I am formally, this is my written request for reconsideration. And I ask that you don't make it, give some more time for me to get information that is coming. We're waiting on my doctor, this kind of thing. The key thing that has to be done within 90 days is you have to request the reconsideration within 90 days. They will, as long as you request it in 90 days, they will grant more time often. If you can show that you actually are trying to get records, they will give you more time because they do that with us all the time. The problem that people run into is they will think you can only request it once you have all the stuff and send it in. That's not true. So we don't wait for doctors' letters. We request it when someone hires us. We request the reconsideration immediately. And I say in the cover letter, we will have more information. We've written to these doctors. We're waiting to get stuff. Please don't make a decision until you get this stuff from us. And they will, within reason. If you're going like a month beyond the 90 days or 2 months, then they're definitely going to probably just make a decision and push you along, which often there's no way around it because it's very hard to get these doctors' reports in time for reconsideration appeals with CPP. Okay, that's a great question. Right in under the wire, right when I was going to sign off. I'll give it another few seconds. Grab a drink of water here. You are welcome, Mina. You are welcome. Just make sure, like I said, get that written request into them. And when you're dealing with another headache of dealing with Service Canada is you can't, well, if you can probably submit things online. So what I would recommend if you're doing this yourself is upload your request online. I haven't been online in a while. Maybe you could even submit, maybe they even have a form on, when online, I mean your My Service Canada account. I'm going to have to log in because they keep upgrading things. I haven't looked at it lately. There may be a place in there where you can actually just submit a request for reconsideration and they have the form right in there. Otherwise, you'd have to fill out a form and then upload it to them, but that's also a way to do it. Don't try to like courier things to Service Canada because they can't accept couriers for whatever crazy reason. The only way to send things to them where you can have some proof that you sent it is by express post from Canada Post. I learned that from an insider that express post can get around. They can actually deliver to PO boxes. Okay, I don't know if I'm supposed to say that or not, but that is the hidden secret knowledge that express post can deliver to PO boxes, but the normal couriers, like through whatever courier you want to use, FedEx or whatever, they can't. They can't get past PO boxes. They can't deliver to one. And Service Canada only gives PO boxes. So it makes it very difficult. You have to mail everything to them, and it's hard to prove that you mailed it before the deadline and all these kind of. So upload it if you can. All right, Mina. Thank you for that. I'm gonna end the stream now. It doesn't seem like there's any more questions, so that's fine. We'll see you guys back here next week. Take care. Have a good weekend. Bye-bye.